California has the most complex and tenant-protective lease termination framework in the entire United States. If you own rental property in California, you're operating in a legal environment with multiple layers of regulation, state law, local ordinances, and an activist court system that consistently interprets ambiguity in the tenant's favor. The governing law is found primarily in the California Civil Code sections 1940 through 1954.06 and the Code of Civil Procedure sections 1159 through 1179A, along with the Tenant Protection Act of 2019, Assembly Bill 1482, which fundamentally changed the landscape for California landlords. Let's start with the most important thing. California is a statewide, just cause eviction state. Under the Tenant Protection Act, codified in Civil Code section 1946.2, landlords cannot terminate a tenancy without a legally recognized reason once the tenant has occupied the unit for 12 months or more. This applies to most residential tenancies throughout the state, with limited exemptions. You cannot simply give a no-cause notice and ask a long-term tenant to leave. The qualifying grounds for termination are divided into two categories: at-fault just cause and no-fault just cause. At-fault grounds include non-payment of rent, material lease violation, nuisance, criminal activity on the premises, refusal to allow the landlord lawful access, subletting in violation of the lease, refusal to sign a comparable renewal lease, and other tenant-caused grounds. No-fault grounds include the landlord's intent to occupy the unit personally or have an immediate family member occupy it, withdrawal of the unit from the rental market under the Ellis Act, compliance with a government order requiring vacancy, and intent to substantially remodel the unit in a way that requires the tenant to vacate. The distinction between at-fault and no-fault termination is critical because no-fault terminations trigger relocation assistance requirements. When a landlord terminates a tenancy for a no-fault reason, the landlord must either pay the tenant 1 month's rent as relocation assistance or waive the last month's rent. This requirement applies statewide under AB 1482, and many local jurisdictions require significantly more. For tenants who have been in the unit less than 12 months, the landlord can still issue a no-cause termination notice, but this window closes quickly. Once the tenant passes the 12-month mark, just cause protections apply. Now let's talk about the notice requirements, which vary depending on the grounds for termination and the length of tenancy. For month-to-month tenancies where the tenant has occupied the unit for less than 1 year, the landlord must provide at least 30 days written notice to terminate without cause. For tenants who have been in the unit for 1 year or more, the notice period is 60 days. But remember, for tenancies of 12 months or more, you now also need just cause under AB 1482. For non-payment of rent, California requires the landlord to provide a 3-day notice to pay or quit. Under Code of Civil Procedure section 1161, the notice must state the exact amount of rent owed, and California courts are extremely strict about this requirement. The notice must include only rent, no late fees, utility charges, or other amounts. Including any amount beyond actual rent due can invalidate the entire notice and force the landlord to start over. California also enacted SB 1137, which added requirements to the non-payment process. Before filing an eviction, known in California as an unlawful detainer action, the landlord must make a good faith effort to contact the tenant to discuss the delinquency. The landlord must attempt contact by phone, text, email, or in-person visit, and must document these attempts. This pre-filing contact requirement applies in addition to the 3-day notice and adds an extra step that landlords must complete before proceeding to court. For lease violations other than non-payment, California uses a 3-day notice to cure or quit for curable violations. The notice must specifically identify the violation and state what the tenant needs to do to correct it. If the tenant cures within 3 days, the notice is void. If the tenant doesn't cure, the landlord can file an unlawful detainer action. For violations that cannot be cured, including illegal activity, nuisance, and subletting without permission after being asked to stop, the landlord can issue a 3-day unconditional notice to quit. No opportunity to cure is required for these serious violations. For repeated violations of the same type, California allows the landlord to serve a 3-day notice to quit without providing another opportunity to cure if the same violation occurs within the same lease term after a prior notice was served and cured. However, the landlord must reference the prior violation and cure in the new notice. Now here's where California gets exponentially more complex: local ordinances. Dozens of California cities have enacted their own rent control and just cause eviction ordinances that add requirements on top of state law. The most restrictive rule, whether state or local, always applies. Los Angeles has one of the most extensive local frameworks in the country. The Los Angeles Rent Stabilization Ordinance covers units in buildings built before October 1978 and imposes just cause eviction requirements, specific notice provisions, relocation assistance obligations, and procedural requirements that go well beyond state law. Los Angeles's relocation assistance requirements for no-fault evictions are substantially more generous than the state minimum. Landlords may be required to pay thousands of dollars per unit, depending on the circumstances. San Francisco's rent control ordinance, one of the oldest in the country, covers most units in buildings built before June 1979. San Francisco's just cause requirements are extremely detailed, with specific procedures for each type of termination. The city's owner-move-in eviction procedures are particularly complex, requiring specific declarations, filing requirements, and post-eviction monitoring. San Francisco also imposes significant relocation assistance requirements and has a buyout agreement disclosure process for landlords who want to negotiate voluntary move-outs. Oakland, San Jose, Berkeley, Santa Monica, West Hollywood, Beverly Hills, and numerous other California cities each have their own local ordinances with their own notice requirements, relocation assistance amounts, and procedural requirements. A landlord who owns properties in multiple California cities may need to follow different rules for each property. The eviction process in California, the unlawful detainer action, goes through the Superior Court. The landlord files a complaint after the applicable notice period has expired, and the court issues a summons. The tenant has 5 days to respond. If the tenant doesn't respond, the landlord can request a default judgment. If the tenant does respond, the case proceeds to trial, which is supposed to be scheduled within 20 days, though in practice the timeline is often longer. California's unlawful detainer process was designed to be faster than regular civil litigation, but in practice, particularly in large urban courts like Los Angeles and San Francisco, the process can take several months. Court backlogs, tenant defenses, continuances, and procedural complexity all contribute to extended timelines. Contested cases can take 3 to 6 months or longer from filing to physical removal. California tenants can raise extensive defenses in unlawful detainer proceedings. The most common defenses include defective notice, which is the most successful defense and the reason California courts scrutinize notices so carefully. The landlord's failure to maintain habitable conditions, retaliatory eviction, discriminatory eviction, and failure to comply with just cause requirements. A single error in the notice, wrong amount, wrong dates, wrong format, inclusion of non-rent charges, can result in dismissal. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant has 5 days to vacate before the sheriff carries out a lockout. However, in practice, the sheriff's office may take additional time to schedule and execute the lockout, depending on the county's caseload. On the tenant side, California provides extensive grounds for early termination. If the landlord fails to maintain habitable conditions, as we covered in our California habitability video, the tenant has powerful remedies including repair and deduct under Civil Code Section 1942, rent withholding, and lease termination when conditions are seriously deficient. California's implied warranty of habitability under Green v. Superior Court is one of the strongest in the nation. Active duty military members are protected by both the Federal Service Members Civil Relief Act and the California Military and Veterans Code, which provides additional protections. California has an enormous military presence, including Camp Pendleton, Naval Base San Diego, Edwards Air Force Base, Travis Air Force Base, Fort Irwin, and numerous other installations. California provides comprehensive early termination rights for victims of domestic violence, sexual assault, stalking, human trafficking, and elder or dependent adult abuse under Civil Code Section 1946.7. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid restraining order, a police report, or a written statement from a qualified professional. The tenant must provide at least 30 days' notice. The landlord cannot charge early termination fees, and the tenant is only liable for rent through the termination date. California also provides early termination for tenants who are members of the armed forces and receive orders for a permanent change of station or deployment, and tenants who are at least 62 years of age and need to enter a residential care facility can terminate with 30 days' notice. California strictly prohibits self-help evictions. Under Civil Code Section 789.3, a landlord who shuts off utilities, changes locks, removes doors or windows, or takes any action to force a tenant out is liable for actual damages. Statutory damages of up to $100 per day for each day the violation continues, and attorney's fees. The statutory damages provision means that even a short illegal lockout can result in thousands of dollars in liability. California's anti-retaliation protections under Civil Code Section 1942.5 are among the strongest in the country. A landlord cannot increase rent, decrease services, or file for eviction within 180 days of a tenant exercising any right, including making a repair request, filing a habitability complaint, or exercising any legal right. The 180-day presumption period is one of the longest in the nation and creates significant protection for tenants who advocate for their rights. One critical practical consideration: California law changes frequently. The state legislature enacts new tenant protection bills virtually every session, and local ordinances are updated regularly. What was legal last year may not be legal this year. Landlords must stay current on both state and local law changes to avoid violations. Working with a California landlord-tenant attorney who tracks legislative developments is not optional. It's a necessity for any landlord who wants to operate lawfully in this state. California requires landlords to return the security deposit within 21 days of the tenant vacating the property. The landlord must provide an itemized statement of any deductions along with copies of receipts for any amounts deducted. California limits the security deposit to 2 months' rent for unfurnished units and 3 months' rent for furnished units. Failure to comply with the deposit return requirements can result in the landlord being liable for up to twice the amount of the deposit in bad faith cases. For the complete guide to California lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.